A journalist was writing an article on rape and murder of a young woman in Bangalore. To humanize and put a face to the story, she wanted to publish the name of the young woman who was subjected to rape and murder. The journalist sought the permission of the parents of the woman because the woman had already died. So the journalist sought the permission of the parents of the deceased, who orally informed her that they had no objection to their daughter's name being published. A published the article in a national newspaper. So there was prior permission taken from the parents of the deceased victim. Now here are the four options: whether A has committed an offence, whether A has not committed an offence. For finding out the correct answer, we need to move to the relevant section. The relevant section is 228A of IPC. Whoever prints or publishes name or any matter which may make known identity of any person, that is the victim, against whom an offence under 376, 376A to E is committed shall be punished. There is an exception to this offence, and the exception is in subsection 2, which says that this provision does not apply if such printing or publication is, and then there are three exceptions. I am just mentioning here the relevant one. If the printing or publication is by authorization in writing of the next of the kin of the victim where the victim is dead. In our case, the victim is dead, so this part will apply. And in such a case, authorization can be obtained, can be given by the next of the kin of the deceased, but it has to be in writing. So I have emphasized this phrase in writing because in our factual matrix, it's clearly mentioned that the permission was given orally. The oral permission does not meet the requirement of subsection 2, and therefore this is no authorization. The authorization is not legally acceptable, and the offence under section 228A will be committed if there is only oral authorization. Secondly, this authorization in writing by the next of the kin cannot be given to anybody like a journalist. The authorization can be given only to the chairman or secretary of a welfare institution which is recognized by the central or state government. So even the next of the kin cannot authorize a journalist to publish the name of the victim. If at all, a written authorization is given by the next of the kin, it can be given only to the chairman or secretary of a welfare institution which is recognized for the purpose by the central or state government. In this case, the authorization was given orally, firstly, and secondly, it was given to a journalist, not to the chairman secretary of a welfare institution, and therefore this authorization is not valid. And since the authorization is not valid, printing or publishing of the name of the victim is clearly an offence under section 228A.